Hi everybody, this is Jeff Fowler with the Apartment Owners Association. Today we're going to be talking about on-site managers and keeping the time cards and some new updates. And we have updated forms with AOA as well, so we're going to be covering some of those things. Before we get into it, AOA has been around for over 40 years, and our goal is to help you make and or keep more money than ever before. And this one's really about keeping it, because if you're not in compliance with California law, the labor laws, then you really could be in deep trouble. And one thing that I want to highlight today is just changes that have occurred in the county criminal files, those court records. There's a lot of information that's been redacted, and what we have now, instant criminal reports. When you're running the tenant screening, no matter who you're using, whether you're using AOA or some other company, they're using arrest records at this point. And as you know, not all criminal history has an arrest with it if you cite and release. And so we've pivoted, and we have a new product called Live Investigator service, and it's part of the tenant screening. It's available to every member, and they will search the county records instead of just jail records, and they'll also do a search on the civil misconduct. And a lot of people aren't aware that civil misconduct's not included in your regular instant criminal search. And anyway, so things like domestic violence and so many other things that are important to us and important to the residents in your community. So really this is something that's going to help your renters be safer, and it's just a tremendous resource. So I want to encourage that one. We also have a new income verification tool from I think a couple months ago. So just a couple different ways that we're trying to constantly innovate and keep up with what you need when it comes to tenant screening. And so those things are available for you. And another thing recently that we've been working on is this right here, and it's the Prop 33, the big lie, vote no to save affordable housing. So there it is. And so we have that in lawn signs, and if you call in or email us, we will get you a lawn sign for free, because many of you have already donated to the AOA PAC for that. And there's a whole lot that we've done. We have a chain mail email that we sent to you. If you didn't get it, you can ask for that. And just so many different things. We're making that Pinocchio a billboard as well. And so anything that you're giving at this point is going to go to putting up more billboards. And anyway, so that's just a side note. That QR code too, it goes into a site where it shares reasons that regular people, not real estate investors, but what regular people would need to know to be informed, to be able to vote no on Prop 33. And anyway, so thankful for the ways that you guys are getting involved, and we do need more of you to step up. And this is Prop 33 is a big deal. Would repeal Costa-Hawkins, and that would really be so damaging to the whole industry, damaging to renters as well as to investors. And anyway, we have so many different things coming up. Next week we have live stream, pending rental assistant applications and how that's impacting rental property owners. And then we have some in-person, it's a there's a lot of different live streams coming up. But in person also next week on the 17th, the speaker that we're having today will be there live in person, along with Franco Simone, who's a landlord-tenant attorney. And so that will be at the Marina Village. Beautiful, beautiful venue. So if you are in San Diego or even maybe Orange County, you may want to head on over to that. And yeah, that'll be great. And then the week after, on the 24th in Buena Park, 25th in Hawthorne, and the 26th in Sherman Oaks, we have a double header. And that will be it'll be about habitability and like landlord rights when it comes to entering the unit. And all three of those will have the same topic. So either Michael Brennan or Dennis Block will be speaking at those. And then we'll also have one about incorporating as an LLC, asset protection. We have a guy that is an expert, has been doing it for 40 plus years, and he will be speaking. So those will be really, really tremendous opportunities to grow, and maybe if you haven't set up LLCs yet, it might be a good time to attend one of those meetings, and we have them again in so many different places for you. And anyway, if you are not getting our emails, you can subscribe. If you go to aoausa.com, you can subscribe. Usually on the bottom right side, there's or just bottom middle, there is a place for you to subscribe to the e-newsletter. And also, if you're watching this from aoausa.com, we do have a YouTube channel. And when you're on the AOA website, there's a little YouTube icon. If you click on that, it'll take you directly to YouTube. And yeah, this is being broadcast on Facebook as well and Rumble. But if you go to the YouTube, you can subscribe and toggle over notifications. That way, whenever we post something, then you'll get it. Sometimes most of the time we're live, but sometimes we just post videos. And so if you hit the notifications, then you'll be informed on that. So that's a whole lot of announcements and everything. So now we're going to get into it. Our speaker today has over 30 years of experience, and really he's an expert in employment law, and specifically a niche for the last several years has been with resident manager law. So he drafts the resident manager agreements. We do not provide those, and people have asked us, but that is an area that we do not want to get into, and we're leaving that one to the attorneys for sure. And of course, everything you hear today, things may change. We don't know when this will be listened to down the road. So things always are changing, and your circumstances may be different. So this is general information. But he defends owners and management companies. He's the chair of the litigation department at Parker Millikan, and he's an adjunct professor at USC. And he writes articles for the AOA magazine. And so it's really my pleasure to bring up attorney Gary Ganchrow.
Hi, I want to thank AOA for inviting me to speak to you here today. Thank you all who are listening, either now or at some time in the future. And I think everything that I have to say, of course, is always very important. But I think this is an important presentation, and one of the reasons I think that is because I know I get asked about these topics that I'm going to speak about a lot. And I want to kind of just give you in the beginning the genesis of how this topic came about in this webinar. AOA asked me some time ago if I would help update the time record that is used for on-site managers, and I was glad to do that. And specifically, Jeff had a specific question about whether or not that time record was accounting for break time, which is something the law requires. I was happy to assist with that. Jeff asked me to speak about it, but it occurred to me that if I got up here and just started talking about time records, not only would it probably be not all that riveting, but it's kind of starting in the middle of the story. Because if we're going to talk about time records, then we are assuming that the person who's keeping those time records is an employee under the law. And I get asked a lot, it's a very common question, whether by owners, usually by owners more than management companies, can they call their on-site manager an independent contractor rather than an employee? That question comes up all the time. So I want to explain, provide some basic legal background, like what makes someone an employee, as opposed to, number one, not an employee, number two, as opposed to an independent contractor. And when I'm talking about employee, I mean a W-2, versus a 1099 independent contractor. And really, with the question that I'm being asked is, well, why can't I just call my on-site manager an independent contractor? I don't want to have to deal with all that withholding and tax stuff and all those wage and hour laws. And what if I call him a key holder? And what if it's my brother's niece's second, great aunt's second cousin? So he's really like close family. So then can I call, can I avoid all that wage and hour stuff? The truth is, a lot of this discussion is going to apply not just to on-site managers, but also to other people who might work on your behalf at a building, including maintenance people. So that's one area that I want to address. Next area, if a resident manager is an employee, whose employee is he? And whose employee should he be? And what I mean by that is often you are dealing with a property owner that may have a management company that's managing the building. So if that's the case, and they have an on-site manager, is that on-site manager the employee of the owner? Is he or she the employee of the management company? And is one better than the other? Then, getting to the topic that kind of brought us here, why do I need time records? And what should they look like? And what happens if I don't have time records? So that's kind of my ambitious schedule here today. And so let's go along for the ride. So let me start with the very basics. What does it mean to employ someone? Now I'm going to give a little bit of a law school lesson here, but it's going to be, I think, bring it down and it will be practical. What does it mean to employ someone? And before you all start walking away from your computers or wherever you're watching and say, well, that's a really stupid question, let me tell you why it's not a stupid question, and let me tell you why you should care. So a lot of times you have a resident manager, but there's someone else in the picture, meaning there's someone living with the resident manager, significant other, a spouse, whatever it is. In preparing for the presentation today, off the top of my head, without really thinking too hard, I was able to think of 3 different lawsuits that I've handled very recently, where there was an allegation by someone that they were employed in 2 cases by the owner of the building, in 1 case by the management company that was managing the building, that they were employed, they'd not been paid minimum wage, none of the wage and hour laws were followed, and that they were owed a whole bunch of money. Whereas my client is saying, what do you mean? We didn't employ you at all. All right, this is not an employee versus independent contractor question. This is, we never employed this person. In each case, the person suing was living in the same apartment as the person who was employed as the resident manager. So this comes up. So back to our basic question, what does it mean to employ someone? How do I even start defending a case where they say they're employed and my client says we never employed them? So the law defines employed to mean to engage, suffer, or permit to work. Now, I can't see anyone's reaction, but if you found that particularly helpful, contact me afterwards, because it's not very helpful. So it doesn't. What does that mean? So here's what the courts say. The courts say when you employ someone, what does that mean? It means you employ a worker by contract, you permit him or her to work by acquiescence, or you suffer work to be performed by a failure to hinder. Plain English. Let's go to the cases I was referencing a minute ago. You have someone who's claiming that they are an employee. Why are they claiming they're an employee? Question number 1, did they actually perform any work? Question 2 is, if they performed work, who asked them to perform work? Was it the owner or the management company, or was it the person they were living with that was actually employed? Did the owner or management company who was employing the resident manager, did they know that that person was performing work? These are the questions you have to ask. And the reality is, if this person was performing work, certainly if they were performing work at the request of the owner or the request of the management company, and or the owner knew that they were performing work, even if they weren't specifically asked to perform work, then they might qualify as an employee under the law. So you have to be careful. But you'll notice something that I haven't mentioned yet, right? What haven't I mentioned yet? I haven't mentioned compensation. I haven't mentioned that they expect to be paid. So that also, according to the cases, is an element of being an employee. There has to be an expectation of payment. When I was preparing for this presentation, I came across a great case. It's not a published case, but it's a case that was decided either earlier this month or last month. A whole bunch of customers, Ralph's customers, sued Ralph's, claiming that by performing self-checkout, they had become the employees for Ralph's, because Ralph's knew they were doing this work, right? It was for Ralph's benefit, so therefore they are Ralph's employees. Isn't that a great claim? The court didn't think so. It threw the case out. But the reason it threw the case out is because, I mean, at least what they said in the opinion, was that no, you had no expectation that you were going to be paid by Ralph's to do your self-checkout. But this comes up. What about a tenant who helps out in the building? You know, someone who's lived there a long time, wants the building to be clean and goes, sweeps the hallways every night. Is that tenant an employee? So again, the answer is not as simple as it may sound. If there's no expectation of payment, even if you know the tenant is doing that, then probably not an employee. But you want to be careful. And when I do contracts, for example, for a resident manager who is an individual, but I know there's someone else living with that person, so I want to be clear in the contract that the resident manager is the employee and the other person is not the employee, because you don't want to run into a situation like we had in those 3 cases I referenced, where all of a sudden you're getting a claim, usually years after the fact, saying, oh, you employed me too and you knew I was working. So you want to be very clear. So that's issue number 1. But usually, more often, I would say the question is employee versus independent contractor. Can I call my on-site manager, whether I call them a resident manager, a key holder, whatever I call them, can I treat them like a 1099 independent contractor rather than an employee? And the answer to that is, well, let me before I get to the answer, I don't want to spoil the element of surprise. Let me explain to you why that even matters. There are a lot of reasons why it matters. Taxes and withholdings is obviously one of them. Whether or not you can take a security deposit from that person might be another reason. I get asked by people whether they can take a security deposit from a manager, and my view, at least, is the labor code doesn't permit that, and you shouldn't. Workers' compensation. Do you need workers' compensation for the person? You do if they're an employee. You don't if they're an independent contractor. There may be penalties for misclassifying a worker as an independent contractor versus an employee, because quite frankly, the government wants its tax money. There are potential liability issue differences where you may have liability for something an employee does, whereas you might not if they're an independent contractor. And then the biggest difference that I'm dealing with, and the one I'm going to focus on here today, are the wage and hour laws. Right? There's a series of wage and hour laws and requirements that you have to meet if someone is your employee that don't apply if they're not your employee, if they're an independent contractor. And again, although we're going to talk, and I'm thinking mostly of on-site managers, the same question comes up often for maintenance workers. When is a maintenance worker your employee? When is the maintenance worker not your employee? So before I get into the actual test, so let's talk about some of the wage and hour ramifications of being an employee versus an independent contractor. And this just gets into basic labor law. So number 1, if we're talking about an employee, especially in this context, we are talking about someone who is considered a non-exempt employee, otherwise often known as an hourly employee. If you have an on-site manager or a maintenance person and they're your employee, they're an hourly employee. You have to pay them per hour. You have to pay them at least minimum wage per hour for their time. And you should not be, and I can't stress this enough because I see it all the time, you should not be paying them a flat amount per month for their work, because that sounds and smells like a salary, like a salaried employee rather than an hourly employee, and it will get you into trouble. And I handle a lot of lawsuits where there's an allegation that my client, the owner or the management company, misclassified someone as an exempt employee when they were really non-exempt, when all they were really doing was paying them a flat amount of salary. So it looked like they were a non-exempt employee. Again, that's not really our topic for today, but I do want to stress that. If someone's an employee as opposed to an independent contractor, you have to give them meal breaks. You have to, if they're applicable, you have to give them rest breaks, and they have to get paid for their rest breaks, which will take us into our timesheet discussion in a little bit. You have to pay them overtime, which probably most people watching know. Overtime here in California is anything over 40 hours a week, anything over 8 hours a day, or any time on a 7th day of work during a work week. Any of those would be overtime, and if they're an employee, you have to account for overtime. You'd have to reimburse for business expenses that they incur on behalf of the business for an employee, whereas you wouldn't necessarily have to do that for an independent contractor. And this will be the focus of our discussion in a little bit, you have to have time records. If someone is your employee, you must by law, and we'll get into this, you must by law maintain time records of the time they worked. You don't have to do that for an independent contractor. So there are a lot of ramifications to this question. So let's get into what the test is. And I refer to this as the why can't I call my resident manager an independent contractor? So I guess I just gave away the answer. You can't call your resident manager an independent contractor. They are your employee. Let's look at why. What's the test? Before we get into the test, I'll give you a case that I handled a couple of years ago, which we'll kind of use to illustrate the principles we're going to talk about. So the case I handled a few years ago on behalf of a property owner, there was a gentleman that used to walk around the neighborhood offering his services for different businesses. He'd help clean, he'd help sweep, whatever they needed. He would do different odd jobs for the different businesses around the neighborhood, and apparently needed the money. My client offered him to work at their apartment building to come do the same kind of thing he was doing for the other business owners. Come sweep, come clean, come do some gardening. And he did that. Well, lo and behold, as I often say in this business, no good deed goes unpunished. And they paid him for his services. But a few years went by and he sued them. He sued them for not paying him the minimum wage. He sued them for not maintaining his hours properly, and all the stuff that we usually see in these wage and hour lawsuits. So the question was he actually their employee, or was he an independent contractor? So keep this case in mind as we go through the different parts of the test. Now, many of you have probably heard of what we call the ABC test, which came into effect a handful of years ago in California, originally through a case, and then eventually through a statute that was passed. The ABC test sets out 3 elements that an employer has to meet to be able to characterize someone as an employee as opposed to an independent contractor. I gotta say, this is a little bit embarrassing, I spent a long time and a lot of sleepless nights trying to figure out what ABC was an acronym for, why it was called the ABC test, and eventually I learned, so I want to save you the trouble, it's not an acronym for anything. I don't know why it's called the ABC test, other than there are 3 elements to it, and I guess ABC were the first 3 letters that they could think of. So let's go through the test. So part A of the test, and it's a difficult test to meet, meaning if you want to call someone an independent contractor, you have a pretty high hurdle to get over. So what the test says is a worker is considered an employee unless the employer proves the following 3 things. Number 1, that the worker is free from the control and direction of the hiring entity, both in terms of the actual contractual arrangement and also in terms of the work that this person performs. So you as an employer, the more you can control the manner in which the worker performs his work, the more likely it is you'll be considered an employer and cannot call him or her an independent contractor. So that's the A part of the test. The B part of the test, which is my favorite part, and it's kind of swallows up everything, is the work that's being performed by this person must be outside the usual course of the hiring entity's business, Which means what? Which means if they're doing a task for you that's part of your regular core business, they're an employee. And the example that the case gives is, for example, if you have a retail store and you hire a plumber, so that your retail store, you don't perform plumbing. That's not the service you offer. You sell goods. So when the plumber comes in, that plumber is performing a service that is outside the usual core of your business. Or if you bring in an electrician, obviously you're not in the electrician business. On the other hand, the case says, if you're a clothing manufacturing company and you hire a seamstress to work at home and make dresses, that's what you do. So it doesn't matter that she's working at home, and it doesn't matter even that she's occasional or part-time. That's what you do, and you're not going to pass this part of the test. Or if you have a bakery and you hire a cake decorator to work on custom designed cakes, right? That's part of what you do. So that's part B of the test, but as you can probably figure out if you're trying to apply this to your own business, there's a lot of gray area. What is the usual course of business for a property owner, right? A property owner owns property, and it's their investment property. So what is the usual course of business? An on-site manager? Yeah, probably. Especially if by law you must have one. If you have 16 or more units, you must have one. You're not going to win an argument that you hired an on-site manager required by law, but it wasn't a core part of your business, because clearly it is. Maybe you have an argument if you don't need one on-site, depending on the other factors. Maybe that's an argument. Probably not one I'd want to make for you, but it's an argument that you could at least make. Is maintenance part of owning a property? You can go down the line and think of different things. Is gardening part of owning a property? Probably not. But you can see there's gray area. What about a property management company? Right? What's the core part of a business of a management company? Obviously, they manage the business, but if they have a construction arm, is that part of their core business? If they hire people and do construction, janitorial, is that part? So again, it's a tough hurdle. But there is at least gray area to argue with part B of the test, depending on what type of people we're talking about. Part C, the third hurdle you have to get over to establish that someone's an employee and not an independent contractor, is that person must be, what the case says, customarily engaged in an independently established trade, occupation, or business of the same nature as the work he's performing. In plain English, what that means is a plumber does plumbing. That's what he does. So if you bring in a plumber, he has an independent, he's not just doing plumbing for you. He's got an independent plumbing business, and he's doing it for other businesses. If someone has an independent, has their own janitorial company, and you hire them and they come into your building and they do janitorial work, they are not just working for you. This is what they do. They have their own independent trade or occupation, and this is it. They do janitorial work. So they would pass that part of the test. If you hire if you're a property owner and you hire an independent management company, right? That management company is an independent contractor. They're not your employee, because this is what they do, and they manage properties and not just yours. It gets a little bit dicier. What if they're only working for you? What if you've got a guy who ostensibly does maintenance work for other people? He's free to do it, but the reality is you tie up all his time. You have multiple buildings, and he works exclusively for you. A little bit of a gray area, but again, you're probably going to lose that argument, because as a practical matter, if you're using up all his time, he probably can't work for other people. So that's the ABC test, and as I said, it's a pretty high hurdle. So let's go back to my real life case of this gentleman who hired himself out to various businesses in the neighborhood, and now my client hired him to work at the building. So is he an employee or an independent contractor? So if you run through the elements, it's a little bit of both, right? On the other hand, you could argue, depending on what he's doing, that what he's doing is not core to the property ownership business, again, depending on what tasks you give him. Does he have his own independent trade or business? Well, he doesn't have an LLC, doesn't have a corporation, but clearly he's hired himself out to other businesses in the neighborhood. And as to the last test, the first part of the test, is he free from control? Again, that depends on the facts. But you can see an argument either way. But you can see there's gray area. And if you have a question, don't just guess, because you might guess wrong. See a lawyer, because you don't want to guess wrong, because the ramifications of guessing wrong are you get a lawsuit, like my client got. Okay, next topic. Let's assume we have an on-site manager. I think we've established that on-site manager is going to be your employee, you as the owner or you as the management company. They're not going to be an independent contractor. You should not be treating them as an independent contractor. So now the question is, and I get this question all the time. I get it from owners, I get it from management companies. Sometimes I get it from owners and management companies who come to me together and say, we're hiring an on-site manager. We understand he's got to be an employee. Whose employee is he? Whose employee should we make him? Sometimes, often, the owner says, I don't want that headache of having an employee. Make it the management company's employee. And the management company will come to me and say, we don't want to deal with that headache, with the potential liability, with the workers' comp, with all that. Make it the owner's employee. And so it's a never-ending battle, and I hear it all the time. So I'm going to introduce a new concept now, and that's a joint employer. Meaning a single employee in California can have more than one employer. There can be a primary employer, usually the one who contracts with that person, but there can be a secondary, a joint employer. And the test for whether or not you are a joint employer is if you either directly or indirectly exercise control over the worker's wages, over his or her hours, or over his or her working conditions, then you will be considered a joint employer. So if you supervise that person, even if the contract says they're someone else's employee, you are going to be considered exercising control over their working conditions, and you're going to be considered their employer. So let's go back to our owner and on-site manager question. I mean, a property management company question. My view is, and I'm pretty confident about this view, that if the property management company hires the on-site manager and makes him or her their employee, they might be able to take the owner completely off the hook from any potential liability. Meaning they are paying the person, they're hiring the person, they are supervising the person, they are controlling the person's work hours and work, and the owner really, at least in my scenario, has no involvement. They hire the management company. You guys, you management company, you do what management companies do, take care of my building, hire the on-site people, take care of them. I don't think there's ever a situation, though, where the reverse is true, where a property management company can say to the owner, you hire the person, you hire the on-site manager, let's do the contract between you, owner, and on-site manager. We don't want them to be our employee, and also escape liability by doing that. I don't think it works for the management company, because the management company, by definition, is going to be interacting with this person. They are going to be controlling this person to some extent. They're going to be supervising this person. This person is going to report, typically, to the management company. So I don't think it ever... Now, there may be other reasons for doing it, practical reasons, why you would want the employee to be the on-site person to be the owner's employee. But from a legal perspective of trying to escape liability, which is usually the discussion I hear, I don't think it ever works to make that person the owner's employee for the management company to escape liability. But the other way around might work. So that's my view on that. What you can do, if you are the management company and you say, all right, we recognize, Gary, the wisdom of what you just said, of course, we're gonna make this person our employee, but we don't want the risk. We don't want the potential liability. So you can adjust for that in your property management agreement with the owner. You can put in language, you can put in an indemnity agreement where the owner agrees to indemnify the property management company for some liability, all liability, flowing from the management company's employment of the on-site manager. So you can kind of escape liability that way. And let me do a little bit plug, because I think I'll be having an article coming out in a couple of months about indemnity and how this all works. But you can escape liability perhaps that way, but you can't escape it directly just by making the on-site person an employee of the manager. I'm sorry, of the owner. All right, now the topic of the day, time records. I love time records. and if you are an employer, an owner, a property management company, you should also love time records. Now, let me clarify that. My practice is typically defense work or dealing with clients and transactional and contracts and that work, but I don't do plaintiff's work. So I have to keep billing records. And if you were my client and you got a bill from me, that bill would reflect the time that I worked on your matter and on no one else's matter. Well, guess what? When I go into the office during the day, I work on multiple matters and often are switching from matter to matter in a matter of minutes, seconds, hours. I'm working on your matter, the phone rings, I hit the clock, I stop working on your matter, now I'm working on someone else's matter. I hate those time records. I hate keeping time. But from the perspective of with the protection that the time records give to you as an employer, they are invaluable. Because almost every lawsuit that I handle involving resident managers, and I handle a lot of them, if it's a wage and hour claim, it boils down to how many hours did the resident manager actually work. And if you've got time records, reliable time records, my job is a lot easier than if you have no time records. If you have no time records, then what happens is you are giving license to the employee to exaggerate the hours that he or she claims she worked. And a lot of times, they may not think they're exaggerating the hours. I find that owners often underestimate how much the resident manager is actually working, and the resident manager overestimates how much they're actually working. But regardless, they have license to say what they want. I had a case once. I got a complaint that I was defending, and when you backed into the numbers, the claim, and it was based on the wages paid, the claim was actually that the person, you did the math, worked more than 24 hours a day, which was remarkable, I thought. Quite a diligent manager that person was. So the time records are invaluable for your protection. And if you don't have them, so yes, I can do my job if I'm defending you and try to, if they're claiming they worked 30 hours a week and you believe the on-site manager only worked 15 hours a week, or they're claiming they worked overtime and you don't believe they worked more than 20 hours a week, we can develop that case. We can talk to tenants. We can put together phone records and text records and receipts and try to piece together what the person actually worked and make the argument. But it's a law of diminishing returns, because you're paying me to do that, and I'm billing it whatever I'm billing at, and so I have to, so you knock down 5 hours. If you pay me $5,000 to knock down 5 hours a week, the math doesn't work. So you don't want to be in that position. It's just a lousy position to be in. So I will concede that time records for on-site managers are what I consider a square peg in a round hole. Right? They don't work, they don't fit. My secretary comes in every day. She comes in around 8:45. If she would have nothing to do that whole morning, which by the way never happens, and she's great and she's always busy, but if she would have nothing to do, she still clocks in at 8:45. She still would get paid to sit at her desk because she's on call, she's ready to work, and if I give her nothing that whole day, she's entitled to get paid for that whole day. For on-site managers, that's not the law. We have a different law for on-site managers, one that really helps property owners, the one of the few. And on-site managers are only entitled to get paid for the time that they're actually performing work. They don't get paid for on-call time. So it's not like they clock in at 8:45 and clock out at 12:45 for their meal break. It's if they're working at 8:45, great. They should be recording their time. If they're not working, they're going up and they're doing their laundry or running some other errand, they don't get paid for that. So it is a square peg in a round hole to ask someone to constantly record time in and time out when they, like me a little bit, are constantly switching between performing a task and not performing a task. So I'm sympathetic when on-site managers say this is a royal pain in the you-know-what, but I'm only sympathetic to a point because I've got to do it. Now, I realize I'm sitting at a desk and they're running around. It's a little bit different. But you want time records, you need time records, and most importantly, the law requires you to have time records. So what do these time records need to show? Is there a way to pull up the time record, that AOA's time record? So let me talk about it a little bit, and then we'll focus on the time record itself that AOA is using. So number one, time records have to show when an employee begins and ends each work period. That's required by law. So again, for my secretary, it's easy to say, okay, I'm clocking in at 8:45 and I'm clocking out for my meal break at 12:45. It's a little bit more complex for an on-site manager, given the nature of the job, but it's required. So you've got to enforce it to the extent you can control it and enforce it. It has to record the beginning and ending of any meal breaks. And depending on how much an on-site manager is working per day, he or she may or may not be entitled to a meal break. If they're working more than 5 hours at a time, they'll be entitled to a meal break. And if they take one, they have to record when they started and when they stopped. They have to record the total daily hours worked. So if you look at the time record in front of you, it's got a lot of clock ins and clock outs, probably not enough. It's the most we could fit on one page, and I would encourage you to encourage your on-site manager to use the back of the page or another page or multiple pages if he or she needs more, because you want to capture it. It's got the time in and out for meal break as is required, and it's got the total hours as is required. So what happens if you don't have these records? So as I said before, number one, you're vulnerable to wage claims, and the burden is on you. If you don't have time records, the burden is on you, the employer, to rebut whatever the employee claims they worked. They say they worked 40 hours. It's your burden to show they didn't, otherwise they're believed. So that's a bad place to be if you're in a dispute. If meal breaks are not recorded and they were entitled to a meal break, there is a legal presumption that they didn't take a meal break. Again, that's a problem for you, because if they didn't take a meal break and they were entitled to, you have to pay them for the meal break. There are penalties involved. Again, not where you want to be. There are different local offices that that can investigate whether or not you've been paying minimum wage. Here in the city of LA, there's something called the Bureau of Contracts Administration, Office of Wage Standards. I'm dealing with them on a matter now where an employee complained to them and said, hey, I wasn't getting paid right. So they get into it, and they want tons of records from the employer, and they have the legal authority to ask for those records. And if you don't have time records, that's bad. So you want to have the time records for all of those reasons. And I'm aware that there's often a battle between the owner or the property management company employer and the employee, because employees don't like keeping these time records. I know that. And like I said, I sympathize. But you don't have a lot of recourse as the owner or the employer, unfortunately. I mean, you don't get to say, I'm not paying you because you didn't give me your time records. We'd like to say that. It's kind of natural consequence, right? You don't give us time records, we don't pay you. The problem is the law doesn't allow that. So your only real consequence is to keep, or power you have, is to keep warning about it, disciplining about it, and then eventually, if it's a real problem, to terminate, because otherwise you are asking for potential problems down the line. I just want to point out a couple of more things about the time record that you have on the screen. So we talked about the table part that has the ins and outs, etc. This time record says that it must be personally completed by the employee. You want it to be personally completed by the employee. You don't want to fill this out for the employee. Because if you do, you are subjecting yourself to a claim that the hours are not accurate hours, unless you otherwise have a really good record of them. So you want the employee to fill this out himself or herself. You want them to certify that this is accurate, because even though I said earlier, I'd much rather have a case with time records than without time records. The reality is that I handle plenty of lawsuits where there are time records. And even though there are time records, the employee is claiming they are not, and naturally the time records don't support the claim the employee is making in the lawsuit. The claim is always, well, those are not accurate. time records. And it can be for a variety of reasons. Either you forced me to fill out those numbers, you filled them out, those aren't really it's not my handwriting, whatever, runs the gamut, what the claims are. But you want to make sure that they are recording the time records accurately and that they are certifying it's accurate, so that when you come to me, if you ever get sued, hopefully you never do, hopefully we meet each other on different terms, but if that happens, I've got a time record with an employee that says, I am certifying under penalty of perjury that these are my accurate time records. They can say what they want after that, but I've got a pretty good head start once I've got that signed. You want to make sure they sign it. You want to make sure they really give it in. You want them to certify they've not worked overtime, assuming that, of course, is true, because you don't want an overtime claim. And you want them on the hook and on record as having certified that there was no overtime. And you want them certified they've taken their rest breaks, because you'll notice, although the law requires them to record in and out for meal breaks, they don't have to record in and out for rest breaks. And the reason is because they're entitled to be paid for rest breaks, 10-minute rest breaks. So you'll notice that the time record says they must take a 10-minute rest break for every 4 hours they work. And you want them to certify they've taken them and they're entitled to be paid for them. I'm not going to tell you this is the ultimate time record. You can't use something else. You can, of course, use an app. There are plenty of good apps out there. You can come up with something on your own, but these, I think, are the basic elements you would want to have in any time record for your protection. And I will close out now. Thank you very much for your attention. And I guess if there are questions, I'm happy to take them.
So if you have a question, you can put that in if you're on AOAUSA.com. There's the blue help button. You can use that to ask a question. Make sure I'm on here. And go ahead and get that question asked. I see one has come in already. If you're on YouTube, Facebook, go ahead. Please ask the question and we'll get to it. And are we good? I'll just adjust that one. All right. All right. So I love moves on YouTube. Can you please clarify 16 or more units, attached units in one building, or all structures, separate buildings under one ownership and one contiguous parcel of land? So
I'm going to duck this question a little bit, and I'll tell you why. Because I'd want to have the regulation does talk about contiguous buildings, and it matters whether or not they're on a single parcel. But I would want to have the regulation in front of me to answer that question, because I want to make sure if I'm going to give you an answer, I get it right. If you want to contact me back in the office when I'll look at the regulation with you, I'm happy to answer that. I just don't want to give you an answer off the top that may be wrong.
Great. All right, if you have another question, go ahead and put it in. Yeah, good to know. Hopefully you're not doing a 1099 on your people, and hopefully you're getting these time cards done. And while we wait for another question, so can you tell us about how does it have to be in the contract to get the resident manager to comply with actually filling out the timesheet? What's your experience?
I don't think as a matter of law it has to be in the contract. I highly recommend putting it in the contract. Because if you do have a hard time getting the manager to comply, and which is not infrequent, it's nice to have that provision in the contract saying they must give you time records. When I do contracts, I say this is a material term of the contract. So if I reach the point where I'm an owner or a management company and I need to terminate an on-site manager because they're just not giving me time records, I can do it without that provision in the contract. But it's sure nice to have that provision in the contract to point to and say, look, we agreed up front you were going to do this, now you're not doing it.
Great, all right. Farbia on YouTube, my resident manager contract sets forth we expect minimum of 10 hours of work a month to be paid minimum wage. Is this okay?
There's nothing inherently wrong with that. There's nothing wrong with requiring a minimal amount of work. There's nothing wrong with requiring a maximum amount of work, meaning I don't want you, on-site manager, to work more than X amount, assuming they can really do the job, in those hours. You can't cap their hours and then ask them to do more work than they can do in those hours. As long as you are paying minimum wage for all of the hours worked. Meaning if this person works 12 hours, you're paying them at least minimum wage for the 12 hours. They work 15 hours, you're paying them at least minimum wage for the 15 hours, then that's fine.
Great. All right. Next question. What if, okay, is it I love moose? So remember, he just said that he wanted to look it up, but you have another question here, and I don't know that he'll have the answer for you, but what if two parcels of land bordering next door to each other, each having two fourplex buildings, one owner, is resident manager required in this specific scenario?
So it sounds to me, if my math is right, and I don't, and I'm not saying that to be funny, I want to make sure I'm not missing something, but if it's only 8 units combined.
Oh no, I think there's two fourplexes on each parcel. So
got it. So it is 16 combined.
Yeah.
Okay, so this is, again, I want to look, I want to look at the regulation. I don't want to be guessing at what I'm familiar with the regulation, but I want to have the language in front of me before I answer that.
And so and then also one question I had even just this week is, hey, is 16 units, is this just for the city of LA, or is this a California law?
The 16 units is a California law.
Okay, that's California law. Okay, Scott, what are the appropriate ways you can compensate a resident manager?
So that's a whole other topic. Scott, I don't know where you live. Drive down to San Diego. We'll be talking about that next Tuesday. It's a hard question to answer briefly. There are a couple of different ways that you can compensate a resident manager. The basic ones being through a rent credit or through what we call a check exchange, where you are actually paying them out of pocket. There are nuances to each way. There are caps each way. There's a whole series of regulations each way. So those are the two basic ways. But I would. It's a longer discussion to really break down the advantages and disadvantages of each.
Looks like we have fodder for another live stream. All right. If you have any other questions, please get them in. We'll wrap up here in a second. And again, we're going to be down in San Diego next week, and he'll be live, so that'll be a time when you can ask more questions. And you can give him a call and expect him to give you maybe 5 minutes of his time and maybe one simple question. What if questions are, end up like taking a whole lot of time? Please don't ask him a what if you have something concrete. He can, give you 5 minutes of his time and figure out, whether you need to hire him or not. And so that's kind of, would that be a fair expectation for him to not take too much of your time?
Sure.
Yeah. So that's kind of honor his time, and he is there to make a living and feed his family and everything. So just be aware of that. And so thank you all for listening. Now, many of you may know other people who are resident manager who have a resident manager. Please share this video with them, because so many people just don't even know what the requirements are. And so this is really essential information for every owner who has a resident manager or maintenance people that should be considered employees. So get the message out there. Thank you so much for watching with us today. And hopefully we'll see you in person sometime soon, or on the next live stream. So we'll see you next time. Thank you so much.